Welcome back. What happens if you die without a will in Utah? It's a good question. What happens if you die without a will in Utah? Well, that's a very common estate planning question that people ask. And that is, what happens if someone dies without a will? In legal terms, when someone dies without a will, we call that dying intestate. Intestate means you've died without a will. When someone dies intestate in the state of Utah, their property is distributed according to the state intestacy law rather than according to the personal instructions in what we would call a will. These laws are called intestate succession laws, and in Utah, they're found in the Utah Code, section 75-2-101 et sec. In order to distribute the decedent's property, decedent is the individual who has passed away. In order to distribute the decedent's property, you need to file a probate case in the state of Utah. Filing a probate case means that you draft and file a petition to probate the intestate estate, and you file that with the district court in the county in which they passed away, or wherein they resided when they passed away, or where they currently own property in the state of Utah. So, for example, Utah Code section 75-2-102 explains what happens when someone dies leaving a surviving spouse. In some situation, the surviving spouse will receive everything. They'll receive the entire estate. In other situations, the estate may be divided between the spouse and the decedent's children. There is no surviving spouse. Sometimes the law moves down the family tree, kind of like this. And sometimes it goes out, up, and down, depending on the family tree and who's alive and who's not alive. Under Utah Code 75-2-103, property may pass to children, parents, siblings, grandparents, or even other relatives. The key point is this: the court will simply follow the statutory rules. It does not evaluate your personal relationship. If you were living with someone, you had a partner, you had a best friend, you had somebody that you wanted to receive something, they're not going to do that. They're only going to follow the code, which is what judges do. Judges follow the Utah law. So judges don't know your intentions. And even if there's a handwritten note, most of the time those things are inadmissible because they don't follow the formalities required for a will. Another important issue arises, and that's regarding who manages the estate if someone dies intestate or without a will. When someone dies without a will, they will usually name a personal representative, or what we call an administrator of the estate. Sometimes they're called an executor. That's an older word, or an executrix if it's a woman. But nowadays we simply use the phrase personal representative. But if someone dies without a will, the court must appoint an administrator of the estate. And the procedures for doing that are found in Utah Code section 75-3-203. Family members may need to petition the court and wait for approval before they can begin managing the estate, which means sometimes there can be a long delay. Sometimes it's only a few weeks. Sometimes it can take months. I've seen cases where it's taken over 6 months because people are fighting about things. So this delay is also a delay affecting financial accounts, property, debts, other assets. And for families already dealing with grief, these complications, man, they can just add a lot of stress. So dying without a will also means there are no instructions regarding guardianship for minor children if there's a minor child that needs to be taken care of. If parents pass away without name of guardian, the court must determine who will take responsibility for raising the children. Although courts try to act in the best interest of the child, they cannot know the family's wishes as well as the parents themselves could. That's why creating a will allows you to control these decisions. You can name beneficiaries. You can appoint a personal representative. You can nominate guardians for your children. You can take control of your estate. If you would like to help to either create a will or a trust, or if you need help probating an estate because a loved one has recently passed away and you need help, give my office a call. I'm attorney Jeremy Eveland, 801-613-1472, or you can click on the link in the description below, fill out a short application, see if we might be a good fit to work together. Thanks for watching.